So, one of the ways to have a healthy attorney client relationship and to ultimately contribute favorably to the outcome of your own criminal case is to approach the terminology and the events of your criminal case with curiosity. And what I mean by that specifically is to treat the terminology and the events and the names that we use like you're learning a foreign language. When I was in law school, I had a professor tell me that the study of law and the practice of law is the study of the English language. And what she meant by that is what courts often find themselves doing is taking everyday terminology or terms that are used in the Constitution or in statutes and defining them, right? And over the course of 200 years of court decisions, particularly the U.S. Supreme Court, we have all these definitions that they've been forced to render. Like if you ever saw the movie about Larry Flint and Hustler magazine, you may have gathered or may have known that the U.S. Supreme Court had to define the term pornography. Likewise, the Supreme Court has had to define terms like reasonable suspicion, reasonable doubt. Once the U.S. Constitution was amended to allow for a federal income tax, the U.S. Supreme Court had to define what income is because there was a challenge related to the IRS taxing some money that an individual earned from a company. So the study of law and the practice of law in many respects is the study of language. Likewise, you as a client should apply some curiosity and some detached analysis when you are engaging in your case. And what I mean by that, you're going to hear terms and labels for court events and other things related to the law that sound like everyday terms, like an arraignment or a pretrial conference or a battery or an assault. And you may have heard of these things before, or if you had a criminal case in another county or another state, you may have literally gone through these same court events before, and you may find yourself thinking that you know what these things are, right? A pretrial conference, for example, sounds like a conference that happens before your trial, right? But what I've come to learn as an attorney and what I oftentimes counsel my clients is that these terms are not always intuitive. And sometimes counties use the same term for different events, and certainly different states use different terms for different things, or I should say the same terms for different things. So for example, in Florida, assault is the threat of violence, like pulling a gun or a knife on someone. Whereas a battery is committing violence, an actual touching or causing harm to someone else. You may live in a state where the term assault means hurting someone. And really in everyday parlance, everyday use of our term, we typically use assault to mean that you violently attack someone, right? We hear that all the time in the news. This person assaulted that person. But if you're in Florida and you're accused of assault, you're not accused of actually hurting someone. You're accused of threatening to use harm against someone, right? So what we have to do is we have to apply some curiosity, and you have to remember that just because a word or a term is something that you've heard before, either in everyday parlance or in another case, or if you're just sort of dissecting it in your head like pretrial conference, it doesn't necessarily mean that's how it's being used in your case in Monroe County, Florida. So, a good way to contribute to the success of your case and for your own mental sanity as you're going through a criminal matter, apply some curiosity. And remember, these terms are not always what they seem.